Good evening, everyone, and welcome to another version of my legal presentation, which I present to you weekly. And this is concerning legal topics that are important or relevant or that we hear about in the news. And I'm just here to enlighten people as to certain facts and aspects of the law, particularly as they relate to my areas of practice, which are personal injury and criminal defense. And I appreciate you tuning in. If you like what you hear today, please at some point hit the like button, but also feel free to comment below and leave comments. I appreciate your comments and your criticisms and your questions in particular. And I often tailor entire segments toward answering questions that come up. And you guys have asked some very, very good questions. I appreciate anybody tuning in to watch this. But the topic that I'm going to cover today is the topic of stand your ground. And I'm going to deliver a primer on this. This isn't going to be a full-length presentation about stand your ground, but I'm going to give you an introduction to it. And over the next few weeks, I'm going to expand on it and have guests over who are fellow attorneys, and we're going to discuss certain aspects and certain cases that are relevant and have helped develop the stand your ground law the way it now applies in Florida. But to understand the stand your ground laws as they apply in public, you first have to understand their origin. Now, stand your ground is actually a reflection, nowadays at least, of an old English law called essentially the Castle Doctrine. It was an old English doctrine that allowed a person to defend themselves in their own home without having to retreat if they are lawfully in their own home and the person that they are attempting to use force against is in the act of doing something improper or is in a place they shouldn't be. That's putting it sort of basically. But Florida statutes have codified the Castle Doctrine in Florida Statute 776.013, which applies to home protection. So it's kind of important to know this a little bit up front. According to that statute, a person who is in a dwelling or a residence in which the person has a right to be has a right or has no duty to retreat and has the right to stand his or her ground and use or threaten to use, first, non-deadly force against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself, herself, or another against another's imminent use of unlawful force. Or they may also use deadly force if he or she reasonably believes that using or threatening to use such force against another to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. So when you have a reasonable belief that you yourself or another who have a right to be in the residence are in danger of imminent death or great bodily harm, or if somebody is committing a forcible felony against you, that is one of those times where the Castle Doctrine allows you to use commensurate force and deadly force at times. And forcible felonies are essentially defined as felonies that involve the use of or threat of physical force or violence against another individual. And we're used to seeing those in crimes such as murders, sexual batteries, carjackings, robberies, arsons, and that's just to name a few. That's not an exhaustive list. But if somebody is in the course of committing a forcible felony and you're in your home and they're doing it there, you have the right to use force and deadly force against them if you are in imminent fear of that being used against you. So there's also a presumption under Florida Statute 776.013. This presumption, which is in subsection 2, indicates that a person's presumed to have a reasonable fear of imminent peril of death or great bodily harm to himself or herself or to another when using or threatening to use defensive force that is intended or likely to cause death or great bodily harm to another if the person that they're going to use the force against, the person was unlawfully and forcefully entering into their home and their dwelling, their residence, or even their vehicle. And the person was removing, but also, if the person was attempting to remove another from a home, a dwelling, or a vehicle against their will. Now, the person who uses or threatens to use deadly force has to be aware that these things are going on, because the defense only applies to a legitimate belief that this is occurring. So it's very, very important that you have this belief. Now, there are certain situations where in the home this doesn't apply. So you're not allowed to use this measure of force against a person that has a rightful a right to be in the home, a lawful right to be in the home, or is a resident of the dwelling, unless there is some sort of injunction against them. So it's very, very important that you not use this against fellow residents, fellow relatives in the home, people that have a right to be there, and unless there is some legal basis for them to not lawfully be able to be there anymore, like an injunction. The other exception is a person maybe perhaps removing a child or a grandchild, and if this person has the lawful right under the law or under guardianship to remove the person from the home, then you can't use force against them to prevent it. If the person who uses the force and seeks immunity from prosecution is actually perpetrating a violent crime or some criminal activity or a forcible felony to others who have a right to be in the residence, then obviously that wouldn't apply to them. And obviously a law enforcement officer who enters the home or attempts to enter a dwelling or residence or vehicle in performance of their official duties, and they identify themselves in accordance with any applicable law. If they are present, then the person does not have the right to use force against the law enforcement officer once properly identified and there for a legitimate purpose. Now, if a person were to unlawfully enter by force a person's residence, their dwelling, or their vehicle in an attempt to commit an unlawful act, then it is a presumption against them that they are committing a violent felony or a violent crime. So that's essentially how the castle doctrine works. That's kind of wordy, but essentially when you are in your castle, your home, you do not have the duty to retreat. If you are legally there, you can use force and even deadly force in certain situations, as long as you're not using it against another person who's lawfully in the home. So that's the castle doctrine, and that's kind of the basis for the stand your ground. And stand your ground is a sort of the evolution of self-defense in public, the way we experience it in Florida. Self-defense was typically an affirmative defense that a defendant could allege if they're accused of a violent crime. They can allege, yes, whatever the state is saying here is true. However, I allege the affirmative defense of self-defense, and if the judge grants that instruction, then the jury will hear it, and then it can rule upon self-defense as being applicable in the case or not, and possibly mitigating or exculpating a defendant who's accused of a violent crime. So the way the statute has been rewritten, and now this is statute 776.012, this is use or threatened use of force in defense of person. And this is where the stand your ground essentially now exists in the statutes. A person is justified in using or threatening to use force, except deadly force, against another, when and to the extent that person reasonably believes that such conduct is necessary to defend himself, herself, or another against the other's imminent use of unlawful force. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. And this is the non-deadly portion of it. Look how closely it tracks to the Castle Doctrine statute, 776.013. And then there's subsection 2, and this is the part that the most controversy and most cases seem to revolve around. Subsection 2, which deals with deadly force, says a person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself, herself, or another, or to prevent the imminent commission of a forcible felony. Again, the law defines a forcible felony as essentially any felony which involves the use of threat, of physical violence, or force against any individual. And I indicated that some of them were murder, robbery, arson, and that's a non-exhaustive list. So a person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat. And there you have it, right out of the Castle Doctrine. They do not have a duty to retreat and has the right to stand their ground if the person using or threatening to use a deadly force is not engaged in any criminal activity and is in a place where they have a right to be. So this essentially is tracking the language of the Castle Doctrine statute almost word for word. And in creating this current version of Stand Your Ground, and I heard an attorney put it this way once, and I thought that was pretty good, the Florida legislature has essentially taken the Castle Doctrine and transferred it from the castle to the street. And that is as good a way of putting that as I've ever heard. And in doing so, the legislature took what was the affirmative defense of self-defense and morphed it into an immunity, sort of. And in a number of situations, it diminished a citizen's duty to retreat or attempt retreat, which had previously always been the rule in public places. You always had to attempt to retreat or retreat if you could. But the Stand Your Ground doctrine has eliminated the duty to retreat if you reasonably believe that you're in you're under an imminent threat of great bodily harm or death. Then you have no duty to retreat. But before the Stand Your Ground laws were created, a citizen, when confronted with violence or the threat of violence, essentially had a duty to retreat in public, or at least attempt to try to get away if they could safely do it before resorting to the use of force and deadly force. Whereas traditionally, practically, Stand Your Ground laws allow people to respond to threats of force without fear of criminal prosecution. Now, roughly half of the states have passed some form of Stand Your Ground laws, and in the states that have more traditional self-defense laws, it's prescribed that a person under the threat of physical injury does have a duty to retreat. So half the states in the United States still operate under the idea that a person, if they can retreat, should attempt or should retreat if they could safely do so, and only respond to deadly force when the effort to retreat is impracticable or unfruitful. So the Stand Your Ground laws have become much of a debated topic, and they've generated a lot of news in Florida and a lot of case law. Ironically, the case that seemed to bring the most attention to it, which is the most publicized matter of Trayvon Martin and Douglas Zimmerman, where Trayvon Martin was returning home from a friend's house, and Douglas Zimmerman, who was a neighborhood watch person, he observed Trayvon and reported him to the police. The police instructed Zimmerman not to confront Trayvon Martin. However, Zimmerman ignored that directive, approached Trayvon Martin. They got into a physical altercation, and the rest we know is history. Douglas Zimmerman shot Trayvon Martin to death. Interestingly enough, while that case seems to have brought the Stand Your Ground paradigm to light publicly, it wasn't even a case where Stand Your Ground was asserted as a defense. Douglas Zimmerman didn't rely upon it. But that sort of drives the point home as to how confusing it can be for some people. They're hearing these legal concepts sort of run together, Stand Your Ground, Castle Doctrine, retreat, and so forth. And people don't understand that they don't always mean the same thing, and there are important distinctions. Now, apparently, according to the National Federation or the National Conference of State Legislatures, roughly half of the states now have Stand Your Ground laws. Florida's does seem to stand out, though, among states. We were one of the first to pass a Stand Your Ground law of this kind, and there are a few reasons why Florida is so noteworthy. First, it's the fact that the state law says that a person has no duty to retreat, like we talked about, and I've kind of beaten that horse pretty good right now. They have no duty to retreat when they're in a place where they have a right to lawfully and are permitted to be. So, once again, you have no duty to retreat if you can be there, and you don't have to attempt retreat or retreat. And second, the state's laws provide immunity from criminal prosecution and civil actions, which differ pretty much from any other Stand Your Ground states. And though it's not immunity, strictly speaking, because the state may proceed against you in criminal prosecution, it's incumbent upon the defense to raise the issue of Stand Your Ground. So it's not, like I said before, it's not exactly an immunity because the state can proceed forward on charges. However, a defendant is in a position through his counsel to have the issue raised and then possibly addressed in a pretrial conference. So if they have the grounds to raise the motion to dismiss for Stand Your Ground, it can be raised in a pretrial proceeding before the court, and the judge, as a matter of law, will rule by clear and convincing evidence. And there were some proponents when they passed this law to actually create a burden for the state to prove beyond a reasonable doubt that the defendant isn't entitled to the stand your ground defense. So that's where it's a little bit different. Typically, historically, if a person was attempting to assert a self-defense defense, essentially it would go to trial. The state would have to prove its prima facie case, in other words, introduce evidence to meet all the elements of the offense, and they would then the burden would then shift to the defense if they've asserted an affirmative defense to prove their affirmative defense. Now, what the stand your ground statute does, and what makes it unique in Florida in particular, is if stand your ground is asserted, the burden shifts to the state to prove by clear and convincing evidence that the defendant is not entitled to that instruction. And once again, that's handled in a pretrial hearing. So the burden shifts on the state. The defendants no longer have to prove their defense of stand your ground. The state is in a position where it must address that issue and address it pre-trial. So a jury may never even get to see the case. So interestingly, by creating the stand your ground doctrine the way it exists now, and by creating certain immunities for a wider variety of violent actions, potentially, it probably created more prosecution, but at the same time, with the dismissal at pretrial, also created a mechanism whereby it kind of, cut down on the amount of litigation, because, the ability for the judge to dismiss these without a trial is certainly conserving judicial resources. So that's pretty much all I wanted to discuss today in this primer. Just kind of give you an idea of what it is, where it comes from. And next week, I expect to have attorney Hunter Chamberlain on with me, and we're going to talk about some of the cases and how this has evolved in Florida, because it is a very, very interesting topic. But, the takeaway from this, and please, I'm not trying to give legal advice here on how you should conduct yourself in the streets. I'm just going through the history of the statute, what it is, and what it tells us. So, remember, the difference with this one is if you reasonably believe that you have that you're in imminent danger, you then do not have to retreat. And that's really the substantial difference, and also the procedural difference in the way the motion to dismiss is conducted at the pretrial stage, and that a jury may never see a case if the court is satisfied by clear and convincing evidence that the defendant is entitled to be acquitted on the stand your ground defense. But that's it for this evening, folks. I thank you for tuning in. I certainly appreciate it. I appreciate your comments and criticisms. And if you like what you heard today, please feel free to hit the like button or comment and share the information. And thank you very much. And please join me next week. And if you have any questions about anything I discussed here, or wanted to get into greater detail, or somebody that requires legal assistance in this area, please have them call me at the law offices of Christopher DeBarry and CDB Injury Law at 727-656-7852. Thank you very much, and everyone have a great evening. Bye-bye.